possession. So now we move to what I was speaking about earlier, which is about having access to the value of the asset. Not the right to live there, but how do we put some value into this asset, and I want to, if you're thinking about what the experience in Toronto is, we have a condo together, the relationship has ended, we're just going to sell the condo, we're each going to take half and go on our merry way. That would be how things would work if you had a condo in Toronto. What does it look like if you're dealing with unreserved property? Well, the law says you're each entitled to one half. Again, pretty basic, but actually quite revolutionary when it comes to dealing with this type of property. And it says that someone who owns the home, the person who owns the home, whose name is on the title or however it's organized within that particular First Nation, has the certificate of ownership, is usually what it's called. That person can't sell that property without your consent, you're the partner. Again, it sort of sounds 1950s, but it's revolutionary for dealing with unreserved property. So I think in thinking about sort of this legislation and how it may affect our clients, I guess the first thing is we're talking about sort of having unreserved property and being able to take the value out of those houses and mortgages and things like that. And I think that for many of your clients, I don't know all where you work, but for my clients, it's kind of theoretical. My clients are living so often, most of my clients are in Toronto, but the ones who have a connection, those who are on reserve, or moving back and forth between the city and reserve, the housing is often inadequate. It is often held by many, many people jointly. It is not necessarily property that even if people wanted to sell, they could sell. The people are living in real poverty. And so this idea that there's this great asset that they're going to get half of, and it's not actually very realistic any more than it is for many of your clients, I'm sure, in the cities, right? Probably most of you are not dealing with, and again, correct me if I'm wrong, but big matrimonial property fights about, $500,000 houses and how you're going to divide the trust fund. Like, that's not the reality of many of the individuals that we're representing. And so, it doesn't address the real problems, which is on a reserve. Maybe you have two people both from that reserve who've been living together for a number of years and they have a number of children together. They want to end their relationship, but there's not enough housing on the reserve. There's nowhere else to go. There's not a shelter on the reserve. And so ending that as if that there's another house down the block or a house where they can go to is not even realistic. So, some of these issues, they come out of this gap that we were speaking about earlier. And there's a number of cases where individuals were dealing with this, but I think it may not be reflective of the experience of many people living on this earth. The other problem is everything is enforced by provincial court. So when I say you go to court and you get this order, or you go to court and apply for the right of possession, you're going to provincial court. And again, those of you who live in urban centers know that there's lots of barriers to being able to just go to provincial court and get an order and make an application. It's even harder when a provincial court is 300 kilometers up the road. You don't have land to assist you, much less a lawyer who visits your community. And then you're going to this provincial court, and that judge may not have any idea about what situation is like in your community or on your reserve. So and again, that's something where the First Nations may choose to come up with a different decision maker and a different dispute resolution process, but it is an inadequacy within this legislation that everything is enforced by a provincial court judge, and a provincial court is not the most accessible place. It's a question that people would have opinions on and that will be debated in the future is, does it correctly balance individual rights and collective rights? Do the rights of First Nations and First Nations communities to govern themselves and hold their own land and make their own decisions have enough respect within this law? And do the rights of the individuals who have tied up their lives with this property and their children's lives and have put their hard-earned money and time into, is that correctly balanced? And so it is a balancing act, and I think different people would have different takes on whether this legislation strikes the right balance. And I think perhaps most importantly for this group, this legislation does nothing to provide any additional resources to people who are experiencing violence. So the First Nation community that has already inadequate housing and no shelter and no culturally appropriate treatment services and is under under-resourced and has problems with the police that are serving their community. When domestic violence happens there, this doesn't address it. This doesn't give any additional resources. It doesn't really address that problem. And so, as much as it has been centered on, this is something that's good for Aboriginal women or for women who are living on reserve. And I think sometimes it's said in the same breath as a bit of a solution to questions about overrepresentation of Aboriginal women and missing and urban women, all of those things. It doesn't really get at that. It gives some good legal rights, but it doesn't really address the fundamental problems that you all know very well about the experiences of Aboriginal women and violence, particularly domestic violence. And so this had this quote from the Executive Director of the Indian Women's Association of Canada. In all the violent situations we have or are facing in our communities, what are the protections going to be for our women? And who's going to reinforce that? First Nations probably don't have the capacity financially or humanly to give those services. I think that voice of that's fine to say that we can write our own laws and that's fine to say that you address this problem doesn't really speak to what this might really look like on the ground. So that I think is the real question that is out there. I think we'll have to wait and see how this plays out, and I think it speaks to perhaps the ongoing work that's needed, that this is not enough to answer some of those questions.